Hello and welcome to News9 Live. I'm Sumaira Khan. Key Supreme Court verdict on same-sex marriage issue has come out. What's the majority verdict in the Supreme Court? Why no right to marriage or civil union for gays? What Supreme Court said about the rights of queer couples, we're going to talk about it. The judges of the Supreme Court bench hearing same-sex marriage agreed that there is no fundamental right to marriage. The judges also agreed that queer couple must be given protection. The Apex Court has held that it is up to the Parliament to enact a law whether to recognize or not recognize same-sex marriages. It has directed the government to take steps to ensure that queer couples are not subject to discrimination and harassment because of their sexuality. The court also said that the right to marry is not a fundamental right. Hence, the argument of same-sex couples cannot be accepted that same-sex marriages are their fundamental right. The court also added that it cannot strike down Special Marriages Act because of its limitation in not recognizing same-sex marriages. The Chief Justice of India comes up with the idea of a civil union, saying that queer couples have a right to civil union. But fellow judges rejected the idea of civil union. And that is why nothing changes for the LGBTQ community after this Supreme Court verdict. Supreme Court also says no to same-sex marriage. So queers have no fundamental right to marry. That is what the judgment has come out with. But yes, it has said that the rights should be protected. The government should ensure that the rights of the queer community are protected. They have also directed to form a committee to look into the demands of the queer community so that their rights can be granted to them, more rights can be granted and their rights can be protected. They do not have a right to marry. That is what the Supreme Court verdict says, because it is not a fundamental right. Right to marry. The Constitution doesn't guarantee queer marriage. Queers have right to enter into a civil union, and Supreme Court can't strike down Special Marriages Act. That's the verdict that the Supreme Court has given. Only Parliament can recognize gay marriage. Supreme Court also states that state must protect queer couples. Queerness is not an urban concept, and this is a big thing coming out from Supreme Court, where they've said that this is not an urban concept, it is not an elitist concept, it is an age-old practice, and people living in villages or far-flung areas can also experience this. Queer couples don't have adoption rights also. Police must not harass queer people, and that is what the Supreme Court has said, and also directed the governments to ensure that queer people and their rights are protected. It is up to the Parliament to enact a law whether to recognize same-sex marriage. Government must ensure that queer couples are not discriminated against. Their rights are to be protected, and the Supreme Court has directed the government to ensure that this happens. So what is the judgment really about? Let's break this down, and to discuss this, I'm being joined by a host of panelists. I'm joined by Anish Gawande, who's founder of Pink List India. And also, I'll be joined by Sonal Gyani. She is an LGBTQI plus activist. Also, Ashish Pandey, who's an advocate of Supreme Court of India. Brijesh is also here with me in the studio. And also, I'll be joined by my colleague Ashok Bagaria. But Brijesh, so basically, after this judgment has come out, what can we say, that nothing changes for the queer community?
Well, by and large, I think nothing has changed. You know, the only good thing is, which has come out, the only good thing, if I may say so, is that, that the Supreme Court has struck down the assertion by the government and others that, that this queer couple or this LGBTQ and all are an elitist concept, or like, it belongs to the modern times and all. They say like, no, this is not the case, and it is also not a disease. It's a normal, you're born that way. It's something as simple as it. And they have also said that it's an age-old practice, and they have requested the state governments to ensure that there is no harassment of the couples. They have asked the police to apply their mind before automatically filing the FIR. They say like, first you have to investigate and then only you can file the FIR. So they have given a lot of protection, or like say talk about their right in the society per se, because harassment and persecution was one of the key issue also plaguing the LGBTQ community. But in the bigger scheme of things, the situation is exactly as it was before the start of this.
So can we say, or can we put it in this manner, that nothing has been granted, but what they were asking
Absolutely.
for, that has not been granted, but even the minority view accepts the challenges that this community is facing, and they should be incorporated. They're showing you the way towards that.
See, the minority judgment was like, which is the Chief Justice of India, Justice Chandrachud and Justice Kaul. They were of the opinion that yes, right to union can be granted, which if was granted could be used to adopt children and all. all, they were also for the favor of adoption of child and all. But the majority judgment, I mean, it was outruled by 3-2, which clearly said that no, there can be no right to union, there can be no adoption. You cannot adopt a child, and also said that since marriage is not a fundamental right, there's no way that can be claimed as a marriage, because same-sex marriages can't be claimed just because they are fundamental rights. So now Supreme Court said that nothing of that sort exists, and they also said that that we are not going to go into or read into or add words to the Special Marriages Act. They said that is the exclusive domain of the legislature, and they have basically passed the buck to the government of India to look into it, to form a committee which will look into the grievances of the community. But yeah, I mean, if you look at out of 10, I would say, of what the LGBTQ community would be hoping for, I don't rate more than 3 or 4 marks.
So other guests are also joining us. Anish Gawande is there with us, Sonal Gyani, Ashish Pandey and Ashok Pagaria. Before I move on to other guests, Ashok, I would also want to come to you first about how do we read this judgment. Are we right in interpreting it in this manner that LGBTQ community gets nothing what they were looking for, or is there any positive that they can draw from this?
Well, technically, there's nothing in this particular judgment for the LGBTQ community, because what they had approached the Supreme Court in 2022 saying was that the court should recognize the right to marriage as far as the queer couples are concerned, number one. The second thing they had said was they based this argument by saying that this is a part of their right to life, which is enjoyed by all citizens of this country. The second thing they said that this was also discriminatory, amounted to the harassment and violative of Article 14, which is the right to equality. They also made out a case that they are not saying that there should be amendments or changes in the personal laws of various religious denominations, but all they wanted was a recognition under the Special Marriages Act to recognize any union between the queer couples. But today, while adjudicating on this very contentious and sensitive issue, there was disagreement between the 5 judges who decided the case. The lead judgment, or the first judgment, was read out by Justice Chandrachud, in which he laid out very progressive things, but he also said that there is no fundamental right to marry, and hence they cannot read into what has not been ordained by the Constitution or by the legislature of this country, number one. Number two, he said that even though the members of the LGBTQ community do not have a fundamental right to marry, but they do have a right to form unions and associations. So what he does is that he comes up with a unique concept of civil union for the LGBTQ community and says the members of this minority community, have a right to civil union, and that civil union has to be recognized by the governments of this country. The third thing he said, he laid down a various slew of directives for the state governments, the union government and the governments in the union territories, and for the police in the country, saying that there should not be discrimination and harassment of this minority group, even though they might be in the minority, but they have some rights which have been given to them by the Constitution, and that needs to be protected. Another very important thing as far as Justice Chandrachud is concerned is that he recognized the fact that, or rather we can say that he's basically rebuffed the argument of the central government, which said that, if you look at this whole idea of LGBTQ rights and the same-sex marriages, this is basically an elitist and an urban concept. The court said that, look, this is not true. There is no empirical data to base such assumptions. And in fact, queer couples and the members of this minority community exist not just in rural India, but also in urban India. So this whole premise that it is an elitist concept or an urban idea has to be done away with. Another very interesting thing Justice Chandrachud said was that he recognized that as far as the queer couples are concerned, even though they don't have a right to marry, they have a right to adopt. They have a right as far as the banking laws are concerned, in the sense that if a queer couple were to go to a bank and open a bank account, they have a right to nominate their partner as a nominee in the bank account. These views, which have been expressed by Justice Chandrachud, have been upheld or rather echoed by Justice Sanjay Kishan Kaul also. So basically, there are two judges of the Supreme Court of India, Justice Chandrachud and Justice Sanjay Kishan Kaul, who are saying that yes, even though there is no fundamental right to marriage, they have a right to civil union, they have a right to adoption, they have other civil rights also. However, this said and done, there are three other judges on the bench, led by Justice Ravindra Bhatt, Justice Narasimha, and Justice Hema Kohli, who basically dismissed this idea completely, demolished this idea, saying that there is no fundamental right. There is no idea as a civil union also, which has been propagated or propounded by Justice Chandrachud. So that gets rejected. And they say that there is no fundamental right, there is nothing that the courts can do, and now it's entirely up to the parliament or the state legislatures to decide whether these kind of rights can accrue to the members of the LGBTQ community. So this is the brief synopsis of the judgment for you, which actually leaves us to the bottom line that there is nothing which has actually changed for the LGBTQ community on the ground. The kind of no rights or obligations have been carved out by this judgment. But the only thing that has happened is that the Supreme Court has rejected their plea to recognize their right to marry.
So this is a brief synopsis, and we will discuss the other points that have been put forward by the Supreme Court in the judgment. Also, this committee that they've asked to form, what are the rights that this committee will look into. But I'm joined by my other panelists and guests. Let's go across to them and look at how they see this judgment. Anish Kawande is joined with us. He's the founder of Pink List India. Anish, how do you see this judgment? Because it basically changes nothing for the LGBTQ community on the ground. The rights that they were asking for have not been granted. The right to marriage is not a fundamental right. That's what Supreme Court has said. So how do you view this judgment?
You know, I think we all started off this morning expecting a far more favorable outcome. I think we were all awaiting this verdict with bated breath. We knew that we had a progressive court. We thought we'd be getting a lot more, if not marriage, then at least civil unions, then at least a recognition of some forms of rights. And all of that has not come true today. I think in many ways, this is an abdication of the Supreme Court's responsibility to queer citizens. We've seen the sort of announcement of a committee with no clear time frames, with no clear idea of its composition, and with no clear locus of authority, which means that we have no sort of process to ensure that any of the directives passed by the court will be implemented in the near future. We've seen this in the past with the other two judgments relating to LGBTQ+ rights, both the Section 377 NALSA judgment in 2018 and the NALSA judgment in 2014, where directives similar to the ones issued today were issued, but not followed in the sort of years following. So all in all, I think we weren't going to the Supreme Court for platitudes. I respect the opinions of the previous panelists in that the Chief Justice's words might have offered some sort of solace and quelled some sort of preconceived notions about queerness, but that's not what you approach the Chief Justice of India for. You approach the Chief Justice of India for a legal remedy. You approach the court for restitution of rights, and the court has failed significantly on all of those counts.
Let's go across to Ashok once more. Ashok, a brief interjection from you. As Anish pointed out, the committee that Supreme Court has directed is to be formed. As Anish pointed out, there is no time frame that has been given. So this is also at the discretion of the government when they form it, and the rights that they will look into.
Well, he's right. Anish is right when he says that there is no fixed time frame as to by what time will this committee be formed, and what are the guidelines, within what time period they will have to frame these guidelines. But now, you see, this was an assurance which was given by the Solicitor General of India, Tushar Mehta, to the Supreme Court of India during the hearing. Now, that happened way back in May, that the Government of India, under the Cabinet Secretary, who's the highest civil servant of the land, there will be a committee which will be formulated by the Government of India, which will look into the rights and interests of the LGBTQ community. Now, it's already been 4 months. We don't see there has been any move by the Government of India to actually set up such a committee. But besides the time frame, there is also no clarity on the composition of the committee, what is the procedure that they are going to adopt, what are the areas they are going to touch on. So in a sense, there is no clarity as such on what the committee is going to do or how the committee is going to function from time to time, what kind of representation, who will be the members of the community, whether the members of the LGBTQ communities would be on the committee or not. Even that's a big question mark at the moment. But now with this judgment coming in, I think, and a little pressure from the LGBTQ community once again, might force the hand of the government of India to finally set up a committee. In fact, what can happen is what I see it as that if this committee is not set up by the government of India in the next month's time, there can be another application which can be filed before the Chief Justice of India saying that despite these directions that have been given to the government of India is actually dragging its feet, doing nothing, and the court should persuade the government to form a committee. And maybe that is how this committee would come into existence. So this is where the matters are at the moment, and he's right, Anish is right, that there's no clarity on the composition or the working of the
So one positive that has come out of this judgment, that a committee should be formed that should look into the rights. There is no clarity on that also, but let's hope that the government forms a committee as soon as possible since the judgment is now out. Let's listen to what CJI had to say about this judgment.
Conclusions and orders of enforcement. In view of the discussion above, the following are conclusions. This court is vested with the authority to hear this case. Under Article 32, this court has the power to issue directions, orders, or writs for the enforcement of the rights in Part 3. B. Queerness is a natural phenomenon known to India since ancient times. It is not urban or elite. C. There is no universal conception of the institution of marriage, nor is it static. Under Articles 245 and 246 of the Constitution, read with entry 5 of List 3 to the 7th Schedule, it lies within the domain of Parliament and the state legislatures to enact laws recognizing and regulating queer marriage. D. Marriage has attained significance as a legal institution largely because of regulation by the state. By recognizing a relationship in the form of marriage, the state grants material benefits exclusive to marriage. E. The state has an interest in regulating the intimate zone to democratize personal relationships. F. The issue of whether the Constitution recognized the right to marry did not arise before this court in Justice K.S. Puttaswamy, 9 judges, Shafin Jahan, and Shakti Vahini. G. The Constitution does not expressly recognize a fundamental right to marry. An institution cannot be elevated to the realm of a fundamental right based on the content accorded to it by law. However, several facets of the marital relationship are reflections of constitutional values, including the right to human dignity and the right to life and personal liberty. H. This court cannot either strike down the constitutional validity of the Special Marriage Act or read words into the Special Marriage Act because of its institutional limitations. This court cannot read words into the provisions of the SMA and provisions of other laws, allied laws, such as the Indian Succession Act and the Hindu Succession Act, because that would amount to judicial legislation. The court, in the exercise of the power of judicial review, must steer clear of matters, particularly those impinging on policy, which fall within the legislative domain. I. The freedom of all persons, including queer couples, to enter into a union is protected by Part 3 of the Constitution. The failure of the state to recognize the bouquet of entitlements which flow from a union would result in a disparate impact on queer couples who cannot marry under the current legal regime. J. In Article 15(1), the word sex must be read to include sexual orientation, not only because of the causal relationship between homophobia and sexism, but also because the word sex is used as a marker of identity, which cannot be read independent of the social and historical context. K. The right to enter into a union cannot be restricted based on sexual orientation. Such a restriction will be violative of Article 15. Thus, this freedom is available to all persons, regardless of gender identity or sexual orientation.
So the majority verdict clearly stated that the court does not want to enter into the realm of legislature. The parliament has a right to frame the policy framework, and if this has to come, if this right has to be granted to the LGBTQ community, it has to come from the parliament. Sonal Gyani is also with us. Sonal, but one important point that was pointed out by the Supreme Court was that the rights should be protected. The government should ensure that the LGBTQ community is not discriminated against. Their rights need to be protected. So do you think that this coming from the Supreme Court would help the community more? Does that change anything on the ground for them?
No, I think like with my opinion on that is really mixed. Things have not changed on the ground since the decriminalization, by reading down section 377, the discrimination sort of still continues. And part of the reason is also marriage pressure and the way society is sort of structured to not recognize same-sex couples. So it just feels fundamentally flawed and contrarian to say that, the state will take care of no harassment or no discrimination. Whereas the root of it is the fact that we are not equal in society. Our relationships are not seen as equal or, marriageable.
So when the court says that let's sensitize people, let's sensitize the police force, the administration towards the rights of the community, you think the government has to act more positively? Just the court saying this does not change anything?
Yeah, 100%. I mean, see, it's always good that there is a push from the court that, there is an implementation, there is sensitization. And this is something that was even, in fact, part of the guidelines of the Supreme Court when the decriminalization happened. And things have changed. We will not say that things haven't changed. But they have led us to this point where we are asking for equal rights and to be recognized as any other couple and to have rights to marry. And so it just, like I said, it just seems like, it just seems like we are going to be in the same place again in 3-4 years.
Yeah. Ashish is also with us. Ashish Pandey is an advocate with the Supreme Court of India. Ashish, you've heard Sonal, you've heard Anish, and they say that the LGBTQ community was looking for far more from the Supreme Court, and they've got basically nothing because nothing changes on the ground for the LGBTQ community after this verdict.
See, I understand that Anish and Sonal are disappointed, slightly disappointed, but personally, I think this judgment is not against them. They should not construe this judgment as something has been said by the court which is against them. You see, if you analyze this judgment, you will find first all the judges, there is no contradiction or contradictory opinion, that queer couple have right to cohabit, right to choose their partners, right to have physical intimacy, and state shall ensure that there is no discrimination or any harassment or violation, violence against them on the basis of that they have chosen their partner in a particular manner. All the judges are in concurrence. Second, you see, two judges obviously said about civil union and they tried to give them a status of marriage. If not marriage, then at least certain rights which are flowing out of this bucket, to use the term used by CGI, the bucket of this particular concept. What three judges, the majority opinion, what they have said, that you see, we understand that there is certain problem. But as far as the court is concerned, there is a very fundamental concept, which is that courts cannot enter into domain of legislature. They recognize that there need to be change, but the change has to come from the parliament. So what they have said, and in that regard, the government of India has also said they are forming a committee, and their statement has been recorded in the judgment. So you see, I think this is a long road, and this today's verdict is step number 1, and this is a welcome verdict where the constitutional scheme of things have been preserved, while the Supreme Court has also voiced its opinion that obviously there is a problem and this needs to be addressed by the parliament. And let's see how this goes forward. I mean, we should wait.
But Ashish, what the community was looking at was that they wanted that societal acceptance of either a civil union or a marriage, because their rights are to be protected as individuals. Yes. That is yes. the case as of now also. Nothing changes after the judgment. So that has not been granted. So they're being disappointed, the community being disappointed is logical.
Judge. I mean, there is no divergent views on this, that marriage is not a fundamental right. So one particular example was quoted by, if I'm not wrong, Justice Bhatt. He said, if there is no right, fundamental right of transportation, you cannot go to the court and claim that roads should be constructed. See, the point is, this has to be done. We understand the way things are moving ahead. India, I mean, we need progressive laws. But the question is, this is a very fundamental question, whether that change has to come from the courts or the parliament. What court has decided today, it's not that the queer people, they don't have right. What they have said, that this has to be legislated by the parliament. So that's why I'm saying we should not construe this judgment as it's not progressive judgment.
Brajesh, what is your viewpoint on this? Because this is a very thin line that the judiciary has also said that this is not our thing. It has to go to the legislature. The parliament has to make this law. So they should be the one doing this.
Well, I mean, I agree with the judge when they say that, that the Special Marriage Act is a law which has to be looked into by the parliament. But the fact of the matter is that, that these people are fighting against the same government in the court. And if you look at the arguments which have been put forward, it's like, that muddai bhi mera, judge bhi tumhara, fir mere haq mein kya faisla hoga, that kind of thing. I mean, I mean, it's all wonderfully phrased that, that their interest should be looked into, it has been decriminalized, police should be sensitized, but where's the sensitization? There's no sensitization. And if everything has been left to the parliament, then, I mean, what exactly has changed post this judgment?
Nothing. And
Nothing
also,
has changed.
all the rights that the LGBTQ community got has come through the courts only. 2014, 2017, 2018, everything came through court, not through the parliament.
Because, the government is also a party. The government is fighting against them. It's not like, that they're fighting against some noble this thing and all, or some alien. The government is against them. They're fighting against the laws of the government. They want marriage. This is being opposed by the government. So, honestly speaking, you seriously think that a committee will be formed which will say that, yes, okay, let's go ahead and change or, change the Special Marriage Act? It's not going to happen. And there's no binding law. I mean, I agree with Ashok that you can petition the court, you can try to expedite the matter, but how many times are you going to do that? They can always turn back and say that it's a century-old tradition. If you expect us to overturn it overnight, it's not going to happen. So it can be done in 1 week. It can be done in 10 years. I mean, who is forcing the hand of the government?
Ashok has also joined us once again. Ashok, Anish, you wanted to point out something? You can.
Can you unmute yourself?
Can you unmute yourself?
Okay, sorry.
Anish, I'll come back to you. Let Ashok point. Ashok, the point that I wanted you to come in with is that what Brajesh is saying, what Ashish also said, Ashish said that we should look at the positives. The positive is that all the judges concurred that they have a right and this right needs to be protected. So is that a positive that can be drawn from this?
Well, if you were to ask my view strictly, the bottom line is there is no positive takeaway from this judgment. This is the way I look at it. Other people might look at it in a different manner, but there's actually no takeaway from this judgment except for the fact that the court have rejected their prayer of the queer community to have a right to marry. Now, there's nothing new that the court has said that the rights, these people have to be protected. They have to be protected. They are the citizens of this country. Just because they have a different kind of a sexuality does not mean that there has to be some special sort of a direction which has to come in from the Supreme Court of India for the government of India to say that, look, you are not going to do this, you are not going to do that, you're going to do this. I could have understood the Section 377 proviso in the Indian Penal Code. But besides that, the problem is that there is nothing really which has come out from this judgment. Nothing. There's almost a status quo kind of a situation which exists even today. I think one of our panelists wants to just interject at this point in time. Let's hear what she has to say.
Yeah, Sonal has to say something. Yes, Sonal.
I mean, like, we are constantly kind of being asked to look at the positives of this judgment, and I'm not saying that there aren't. It's good that they are sort of recognizing us, and they've spoken about the Central Adoption Resource Authority and their guidelines, and also transgender people who are heterosexual have now clear marriage rights. So I mean, But it's literally like feels a bit like throwing peanuts our way, because even if you talk about the Kara guidelines and they talk about a union, all this while we were fighting this court and waiting for the verdict, the community was being thrown technicalities, right? That this cannot happen, that cannot happen. Now, when we do go and approach, who clarifies? If we are going to be asked, how can you prove that you are in a union? Because at one point two judges say yes, we'll give you civil union, and then later they are like, no, civil union is not possible. So essentially, you said a bunch of nice things about us, and then said that we can't give you anything good.
Yeah.
We're nice people, but we can't give you rights.
Yeah, Sonal, also what has happened is that the arguments that were put forward by the centre that have been upheld, and let's look at the arguments that were put forward by centre, and then we'll have a clear picture. Centre's argument that were against the same-sex marriage said that concept of Indian family involves a biological man and woman. This was the argument that was put forward by centre. Court cannot change the legislative policy deeply embedded in religious and societal norms. So centre does not want to change that. Union between persons of opposite sex socially, culturally and legally ingrained into a concept of marriage. So this is all cultural, social and legally ingrained into the society. In Hinduism, marriage is a holy union between a man and a woman. This was the affidavit that was filed by the centre. These were the arguments that were put forward. In Islam, marriage envisaged only between a biological man and woman. It can only be between a man and woman. Same-sex marriages cannot be recognized through judicial adjudication. And this clearly said that the court should not intervene in this matter. Recognition of same-sex marriage is exclusive domain of the legislature, and that is what has been upheld by the Supreme Court judgment also, that this is a domain of the legislature and they need to frame the guidelines and the laws. Brijesh, this is what we were talking about, that basically everybody was together in on this. When they talk about Hinduism, when they talk about Islam, when they talk about all the religions, the government, they all say that this is ingrained within the societal norms and it has to be held like this.
Yeah, I mean, they say that, like, in Hindu tradition, marriage is not a contract. So, and similarly, it's very interesting to see whether, it's a Hindu organization or Islamic organization or a Christian organization, they all united against, the WhatsApp messages which we are receiving is, they're all hailing the verdict of Supreme Court as historic or something in sync with the tradition of the society. The fact of the matter is that I partly agree with Ashish when he says that, it's not all a dead thing. But the fact of the matter is that, when you are pushed to look for positives in a landmark judgment, then basically you're accepting that there's nothing there. Like if there's a landmark judgment, if there is there are certain even, throwaways that which changes the reality in any which way, then you can still say that, oh, at least, this 10% is the positive, but there's not much. And it's a landmark, it's a constitution bench which is delivering this judgment.
Ashish, so basically we can say that the viewpoint that the central government had put forward, that has been upheld, and actually the LGBTQ community is standing against the government. So what positive can they expect from them? What positive can they expect from the legislature to come up with?
Let me start by saying that let me give you some different perspective. Let's see if had there been a judgment which is completely in favor of the petitioners, then you need to understand from legal point of view, there is a difference between striking down any discriminatory provision and inserting any enabling provision. So today's judgment, had that been in favor of petitioners, I mean completely in favor of petitioners, that would have been inserting certain enabling provisions. So when we say we are inserting certain enabling provisions, that obviously falls within judicial legislation. Even if the court was willing to go into that realm, you see what could have been done by the court. They could have constituted a committee. That committee could have looked into how many laws are required to be changed, what provisions are required to be inserted. You see, in such context, Government of India proposed that we are forming this committee. That committee will look into all these things. The similar exercise would have been done by the committee constituted by the Supreme Court. So I think in all reasonableness, the court decided that it's better let us give Government of India a chance to figure out what is required to be done, and if they are not doing anything positive, then obviously the petitioner, no one is saying the petitioners don't have a right to go to the court again. So it's a long drawn battle, and let's see how this proceeds. Everyone should keep faith in the system. That's what I would say.
Yes, yes. That one thing I think everybody would agree on, that it's a long drawn process and it will take a lot of time. It took a lot of time to reach here, and I think the journey is still very long. Anish, but what Ashish is saying is that if there has to be any change, if there has to be any legal change, any law that has to be enacted, it has to come from the legislature. So this is the process that has to be followed, and that has and the court has nudged the legislature probably in that direction. Do you agree? Okay, Anish, you're mute. Can you unmute yourself?
Sorry, can you hear me now?
Now we can hear you. Yeah.
Sorry, just to intervene here, I don't think this is a question of the primacy of Parliament. It is a question of the supremacy of Parliament. We've had time and again opportunities for Parliament to legislate upon and discuss marriage equality in particular. There have been 2 private member bills, multiple questions asked in Parliament. This government has demonstrated time and again that it does not want to discuss the issue in Parliament. Therefore, to presume legislative or executive intent at a time when there hasn't been any over the last decade is presumptuous at best and farcical at worst. On top of that, I think the reason for going before Constitution bench was exactly as pointed before. This is a landmark judgment. You know, there are some of India's top lawyers arguing this judgment. They're not idiots. This was not going before a 2-judge bench. This was going before a constitutional bench to create precedents, right? We are in extraordinary times where the judiciary must come up with extraordinary measures to protect the fundamental rights of citizens who are being discriminated against. And this is a question not only of an extension of rights, as Ashish was pointing out, but a denial of rights that are already created through legislation. 2 of the judges argued against the CARA regulation, which is an actively discriminatory legislation that the court has statutory power to strike down. Even that legislation in the majority verdict has not been addressed. Now, more importantly, the court has shown time and again that it has the power to create institutions. Environmental legislation had fallen far behind before the courts took matters into their own hands and created environmental regulation institutions. So in a country where judicial activism has continued for the larger part of the past 3 decades, it is absolutely ludicrous to say that the court should now suddenly take on a more conservative approach and become a Justice Scalia-like US Supreme Court that only focuses on some originalist interpretation. While a certain part of that is true, and there is and I acknowledge this, right? My organization, Pinkless India, we work with parliamentarians to get them to support LGBTQ+ rights. And I believe that any sort of sustainable, substantial progress needs to come through politics. Despite that, in such circumstances, for the court to abdicate all responsibility is a rehashing of its 2013 verdict in Section 377. And in many ways, I am worried that if the same matter, 377, had come up before a bench like this one, it would have been decided very differently than it was in 2018. So I don't even see any reason to celebrate here. In fact, I see genuine cause for concern that the court is abdicating its responsibility on social issues at a time when we know that governments are not willing to take action on politically contentious topics.
Yeah, Ashish also has a point on this. Ashish, yes, and then I go across to Ashok. Yeah, Ashish.
See, I agree with Denise, but there is a distinction, legal distinction we should appreciate. When we talk about 377, you see, that was your conduct, what you do within the walls of your home. That is related to your right to privacy. That is related to your right to opt for partners of your sexual orientation. While we talk about marriage, recognition of same-sex marriage, that has more social implications. So that's why the court is of the view that has to come from the parliament side rather than being a judicial direction. So we need to make a difference between these 2 things. We should not confuse both the issues.
If we can hear Anish.
That it was a social issue.
Yeah, Anish.
Right? This was exactly the logic used in 2013.
No, I agree with you. Brother, I agree with you. I am completely...
the rationale continues even today. And I don't think that access to adoption rights, access to things like extension of life insurance, access to visitation rights in hospitals, of course, these are social issues, but in many ways, the court can decide that these are covered by those same aspects. And there's no reason, I agree with you, maybe marriage is something the court might not have considered itself competent enough to debate upon or legislate upon. But there are a bouquet of other rights tied to marriage that the court could have, in all of its wisdom, divorced from marriage or extended to queer couples by creating some sort of institution that recognizes the union. Because otherwise, there's no way of accessing those rights. because any form of relationship is not recognized. Even the majority verdict, which says that we want to have a recognition of relationships, falls short in terms of defining
Anish,
what those relationships are.
Yeah, so Anish,
how do you define them? So how do I get rights if my relationship is not recognized? You said that my relationship should be recognized. You've not given me any framework in which to recognize it. And so access to any rights flowing from
we need to make a difference here. What court has said that you have a right to choose your partner. You see, this is step number one. Now, if you ask court to recognize at the same level which status has been granted to the concept of marriage, you see, there are n number of legislation which are required to be changed. So the court's job is not to make changes to those legislation, but if the legislation are to be brought, that has to be done from the side of parliament. And this is the rationale. It was not as if the court was required to say that we are recognizing same-sex marriage. The matter doesn't end there. There are n number of things which are required to be done post recognition of this thing from the court. So the court, what court has done today, that they have said that, okay, we are asking government or we are allowing government to go ahead with the matter. And if they are not going ahead, then you have a right to file. I mean, you can petition the court again.
Okay, now let's bring in Ashok here. Ashok, what Anish is saying is that this was a landmark judgment. The LGBTQ community was looking towards the court to come up with some rights, with some framework which gives them more rights as a couple, as society permits them. So that has not been granted. So what is your viewpoint on this? Could the court have done more? Or there was this limitation, or judicial activism could have crept into this and they could have done more for the community?
Well, it's a very difficult question to answer. I would concede in the beginning. But let's look at the role of the Supreme Court in the scheme of things. That the court, or for that matter, the Supreme Court of India, as an institution exists for the interpretation of the Constitution and protection of the fundamental rights of the citizens. Now, here is a case that the Supreme Court was presented with, where there was a group of minority community which basically came to the Supreme Court of India, is that just because we are numerically minuscule, we have been denied the status of equality under the Constitution of India. Agreed. But under that right to equality, you have to recognize that we have a right to marry, and that right to marry, that recognition should come from the court. Now, this is where the problem started. The problem was whether to recognize that they enjoy the same rights as other heterosexual couples are concerned. That is correct position. But whether to say that they have a right to marry was something that they had to apply their minds on. And in fact, all the judges have applied their mind to have taken a more liberal stance towards it. Justice Kaul, Justice Chandrachud, who have said that although we agree that there is no fundamental right to marriage because the Constitution does not speak about it, but what we believe is that, here are a bunch of petitioners who have come to us for the enforcement of the fundamental rights. So what is a middle path approach that we can adopt? Either don't send them empty-handed completely, or don't just throw their petitions out. So what Justice Chandrachud and Justice Kaul did was that they adopted the middle path and said that while we agree that there's no fundamental right to marry, we do recognize that you have certain civil rights to form unions, and those civil rights have to be protected. But there were other three judges on the bench who believed otherwise. They said, while you do not have a fundamental right to marry, you cannot read into the Constitution by the process of judicial interpretation that there is something or a concept called civil rights.
Yes.
So there is also this question of constitutional morality, which possibly guided Justice Chandrachud and Justice Kaul to come to that decision where they said that that the Q couples have civil rights. But the other judges who adopted a more conservative and a strict approach, they said that no, we are not going to recognize that. When there is no fundamental right to marry, there is no question of granting you civil rights also.
Thank you so much, Ashok, for this breakdown of what the court and what guided the court to move towards this judgment. There is nothing that has changed for the LGBTQ community on the ground, yes, but the minority view did recognize and did try to find a middle path. So let's hope that this brings out some positive for the community, though majority of my panelists do not agree with me on this one. But thank you so much for joining us. Thank you so much, Brajesh, for joining me, and Ashok, thank you to you also to bring us this into perspective. But now the ball is in the court of the government, in the court of the legislature, and the parliament has to now decide, also form a committee. So let's hope that a positive comes out from the legislature and the parliament for the LGBTQ community. Thank you so much for joining us.
They picked my husband. He was tortured there for 2 years. He was enforced disappeared. We had no idea where he is. Within 15 minutes, we got the information that the whole area is surrounded by Pakistan Army. I came out from that in disguise, and after 5 to 6 hours, I was in Kandahar. I don't have any message for Pakistan. There is no politician in Pakistan.